Hello. So I have to come to the public and bring public awareness of this particular situation because my complete and total rights have been deprived. And it's willful, it's deliberate, and it's with malicious intent. So I have to come to the public because this is a conspiracy to commit grand theft of my property. This is a effort to silence me. This is an effort to deceive the public and not allow for a true, fair assessment of the circumstances in totality, which include material and triable facts. This is an actual conspiracy to commit grand theft. These are lawyers, and it's a judge as well in Columbus, Ohio, where the voters and taxpayers, the citizens, the community overall has an absolute right to know what's going on in the judicial system with public officials. Yeah, you have to be aware what judicial activity is going on, especially if there's misconduct that involves unethical and illegal actions and ongoings of those that you think are in place, upholding the law, being fair, non-biased, non-prejudiced, and acting in a mannerism in which equates to being impartial. That did not happen in this matter. You have to have the awareness of it. Mhm. Mm. And it's actually a current situation right now that's ongoing. So I have to have eyes on this because I cannot continue to sit back and lie down and have my rights revoked. Um, yeah, because I do have a right to life, liberty, my property, and pursuit of happiness, just like anyone else. I have civil rights, human rights, constitutional rights, yes, US constitutional and actual Ohio constitutional rights. That should never be violated by anyone, period. But then when you have lawyers and you also have a judge that deprives someone of their rights, then it's even more critically important for the public to have the awareness because these types of behaviors must cease. Anyone that does exactly what you're going to see in this particular case that is actually now before the Ohio Court of Appeals, 10th District, 23 AP 670 and 23 AP 671, they cannot be on the bench. They cannot hold an actual legal license. There must be discipline and severe discipline. Yeah, so that anyone out there that ever wants to be a lawyer or that ever wants to be a judge or that might be in the role of either currently will never ever do this to another person again. That has been done to me. I'm not going to sit back and allow it. Everything that I say and that you see written in this document is absolutely true, it's accurate, it's factual. I actually have evidence and proof to back up each and everything that I say, that I've written, point blank, period. None of these individuals will be able to rebut, refute anything, or show anyone or the public, um, anybody, anybody that might be doing a criminal investigation, they will not be able to show any proof in opposition to what I am saying. So I worked at this place. It was CVS Health. I was hired by CVS Health as a nurse care manager in June of 2021. Okay. I was terminated from that role by a supervisor named Darcy Gay on July the 15th of 2022. So there is a settlement in place. It is an EEOC settlement under charge 532-2022-02-705. It is not up to me to say whether this entity did something wrong. You can make that determination. What I will tell you is a settlement was paid. It's supposedly a confidential amount, but it has been determined by the Ohio Department of Job and Family Services Unemployment that my termination was without cause, and it was not my fault. So I actually was awarded my unemployment benefits, and unemployment did do an actual investigation and requested proof from the employer. So it's not up to me to determine whether or not I was wrongfully terminated. I was wrongfully terminated. And what I can tell you is during the time that I was terminated, I was actually participating in protected employment activities under Title V11 Civil Rights Act of 1964 based on race and disability discrimination claims, an EEOC charge, 2 Ohio civil rights charges, and also a whistleblower retaliation charge as well. I filed a race and discrimination claim against CVS Health, Aetna Resources. I found out it's Aetna Resources LLC because that's who's on the pay stub. But I was hired as a CVS Health nurse, as a nurse care manager for them, and I knew nothing else about whatever Aetna Resources LLC is. I filed that claim. Spitz Law Firm, Trisha Breedlove, did not file that claim. They were not hired at the point of the initiation of the claim in U.S. District Southern Division Court, which is 2:2202 519. I was still working at CVS at the time of the filing, and that filing is post another EEOC charge where I was provided a right to sue letter. So I did go and I sued them within the time frame allotted under that administrative remedy in which I had exhausted at that time. I filed an affidavit of indigency, which was approved, and I didn't have any costs associated with that federal case. Spitz Law Firm, Trisha Breedlove, Brian Spitz, Greg Schumacher, Nick Kerr, or no attorney did anything by way of representation in that particular case on my behalf. However, you'll see in a ruling from Judge Chris Brown of Columbus, Ohio, Franklin County Court of Common Pleas, he wrote that Trisha Breedlove had in fact put forth actual work and labor into that particular federal claim filing, and that was completely false. And you can Google it if you would like, or you can request a public record, but you could Google April Clark versus CVS Aetna, and the case will come up 2:2202 on a PACER account. And you can literally look there and see the complaint, who it was filed by, affidavit of indigency, who it was filed by. Yeah, so that case really didn't go very far at all. Now, Trisha Breedlove, she put a motion to stay on the record, and she put a motion to withdraw on the record in the U.S. District Southern Division case. And that is it, and that is all. There are no motions, no pleadings, no briefs, no deposition, no witness interviews, no discovery, no evidentiary work, no pre-litigation research. There is absolutely nothing associated with that case or any of my charges that Spitz Law Firm, by way of Trisha Breedlove, Greg Schumacher, Brian Spitz, or anyone of that firm has done on my behalf at all, point blank period, and they won't be able to prove it. And that is why you'll find that Chris Brown, the judge, ensured that a ruling, a summary judgment in their favor came about, because I actually have a lot of evidence to prove malpractice and breach of contract relative to Spitz Law Firm and their actions. What Spitz Law Firm did do, though, however, was act in their own best interest. Okay. And what they did was ultimately claim that they came to a settlement on my behalf with Aetna Resources LLC and CVS in the amount of somewhat of $34,000 and that is where they came up with 15,028, which would have been 40% of that. Okay. However, there is no settlement. Spitz Law Firm did not come up with any settlement for me on my behalf, that they have any legal binding settlement agreement in hand at all, period. They do not. Okay. And they won't be able to produce it. But they're more than welcome to try to come and produce it if they would like, but it doesn't exist. Okay, so Spitz Law Firm was actually hired on July the 19th of 2022 after I, as pro se litigant, had already put forth a lot of my own labor, blood, sweat, and tears into my own case. I do a decent job at handling my own legal matters as my own representative because I can't afford a lawyer, and lots of people will not take this type of a case that's complex by way of legal aid and things like that. That does not work in this regard. This is a civil matter. I'm not a criminal. I can't be appointed an attorney. Attorney's not going to take this case. I have to fight it on my own. And of course, my livelihood was stolen from me. So I don't have the income. I have to do it on my own. And I have been doing it. I have incurred substantial costs. And now at this point, Spitz Law Firm actually has $15,028 of my money, which are the fruits of, it's payment for the fruits of my labor and the settlement that I got by way of my negotiations and my hard work that had an ultimate result of a settlement of an overall confidential settlement amount by way of an EEOC MSA agreement in 532-2022-02705, where I represented myself solely, exclusively as pro se. Spitz Law Firm did not represent me. Spitz Law Firm did not file an EEOC charge or claim for me, nor did they file any of my civil rights claims for me, nor did they file the OSHA retaliation whistleblower claim for me. As Chris Brown indicated in his ruling, it's all false, it's a lie. Chris Brown of Columbus, Ohio, Franklin County Court of Common Pleas in case 22CV007866 is actually the epitome of, quote, lazy judge, end quote. It is a real thing. It does exist. And Chris Brown is exactly that. Cleveland, Ohio attorney Alex Frondorf went down and filed an interpleader, which is a frivolous, bogus, fraudulent, disguised interpleader. That does not meet the elements of an interpleader at all, point blank, period. And everyone involved in this knows it. But it's a cover up because this is a conspiracy to commit grand theft of my property. Right? It's a money heist. All right. This is where someone like Alex Frondorf and Richard Diageo of Littner Mendelson PC and Brian Spitz and Trisha Breedlove and Greg Schumacher and Chris Brown and everybody that has any insight into this all got together in cahoots and collusion and came up with a way to create a story, which is actually a spun narrative, a web of lies. They're half truths that have been told, leaving out key material facts on purpose, which is an actual misrepresentation, which is actually a very severe offense as far as your professional and ethical conduct pillars and things of that nature go. However, the Ohio Supreme Court Disciplinary Board does absolutely have a grievance on Alex Frondorf and Brian Spitz and Trisha Breedlove and Greg Schumacher. And yet there's no comprehensive investigation that's done on them, and it hasn't been, and it never ever is when you report these bad apple attorneys, fictitious litigators to the Ohio Supreme Court Disciplinary Board. No one ever gives a complainant a call. No one ever asks the complainant for actual evidence to substantiate these claims. They just only talk to the lawyers and things like that that are of the same discipline. Of course, always find that there's nothing that they've done wrong. All right. So I just got a letter recently saying that by no means does the Ohio Disciplinary Board find that Alex Frondorf has done anything wrong whatsoever. However, Alex Frondorf breached fiduciary duty, though, in fact, with my property, along with CVS Health and Aetna Resources LLC. They seized, without implied or express consent, my $15,028, which is the balance owed to me via the EEOC MSA settlement agreement and general release that are in place based on the race and disability discrimination claims and charges, employment claims. And that agreement itself expressly notes that the entire confidential settlement amount is to be paid to me in full, entire sum, exclusively, solely, and directly. All right, within 30 days post the signing of that agreement, which was October the 18th of 2022 by Karen Gaster and myself, okay, with Richard Diageo, and just everybody was present. EEOC, Salvador Lopez. Everybody knows that I'm the rightful owner of this property. All right. Yeah, even Alex Frondor. So, he did do something wrong. And also, he did put in a motion to have my money actually put in a court registry, which you do need that in a pleader. But Chris Brown ignored that motion, right? Chris Brown ignored every single motion, pleading, and brief on the court case record from November the 9th of 2022 all the way to October 27th of 2023, where his staff attorney, Jacqueline Bajas, she created an email thread that we all communicate back and forth to ensure there's no ex parte communications, of course. So she sent the ruling to me, all of us, to show that it was a summary judgment in favor of Spitz. And also, the case record will only reflect, however, October 31 of 2023. But I had the awareness via that particular email thread, and that particular email thread is what we would use often. And it was issue brought up long ago about the pending motions and how there was no address to them. And Jacqueline Baja said back in February 2023 via that particular email thread that the court was moving on the motions back in February because I threatened to file a writ of mandamus on them. But, they never did move on the motions again, and this kept going on and on and on. Then once again, Jacqueline Bajas, via that particular email thread, she stated that the court has had to pick up this case and put it down, pick it up and put it down several times because they have other things to do with trials and court cases and things like that take precedence over this. However, justice delayed is justice denied. And actually, my property was on the line and it had been stolen, and all of these people knew this. So my property was misappropriated. CVS Health Aetna Resources LLC seized my property without implied or express consent. They gained control over it. They held onto it in their hand all the way until issuing Spitz Law Firm November the 7th of 2023, my money of $15,028. They sent it from their revenue on a check entitled CVS Health Pharmacy, payable to Brian Spitz or payable to Spitz Law Firm. They sent it from 1 CVS Drive, Wood Rocket or Woodsocket, Rhode Island, directly to Spitz. Okay. They never did put my money in a interest-bearing trust account, escrow, a court registry, a fiduciary, anything but a fiduciary title, a IOLTA, nothing. All right. And in a pleader, you absolutely need that. If there's some question about some type of money, it needs to be put in some type of a trust, something separate from the revenue of the tortfeasor or the third party stakeholder. Right. So the alleged tortfeasor is CVS Aetna LLC. They kept my money in hand that they actually owed me. They are the wrongdoer. They said they were going to pay me by way of the EEOC settlement agreement and how it reads. However, Chris Brown wants to keep that sealed. So instead of just redacting out the amount, if he doesn't want the public to know the amount, he sealed the entire EEOC MSA settlement agreement. He also sealed Brian Spitz brief, which actually puts out about Aetna and asks for sanctions on Aetna. He actually sealed my answer to the complaint. Okay, so it's a lot of wrongdoing. Where is the transparency? None of this should be sealed because why? Because all of these pleadings that are being submitted actually contain material facts, which are the details that are triable. All right, there's a jury demand on this particular case. Chris Brown overlooked that, and he did it deliberately and willfully in his attempt to deprive me of my rights under the color of law in totality. He is guilty of deprivation of rights under color of law. He has taken away my liberty, okay, my civil, my human, my constitutional rights, my property, and my ability to pursue happiness. All right. And that's unacceptable. He needs to be off the bench. period. And there's no immunity in that. And he absolutely did do that. And each and every one of these individuals are actual criminals and menaces. Each one of them needs to be disbarred and disciplined. And a criminal case needs to be brought against each one of them because they have committed the crime of grand theft. Just like anyone else, they need to be arrested, okay, charged, and imprisoned. All right. So Chris Brown, he never did anything on any motion from November the 9th, 2022, all the way to October 31st of 2023. Then when he finally did, because I'm exposing everybody publicly, he finally just went and picked and chose which ones he wanted to rule on and hurry up and get them done. So he just said, hey, whatever. He made up a bunch of lies. What he's saying in his ruling relative to the actual work that Spitz Law Firm did on my behalf as far as representation and utilization of their education and expertise to ultimately end up in an overall judgment or settlement for me on my behalf is a bold-faced lie. Spitz Law Firm has never seen any type of cause of action of mine all the way through to an ultimate settlement or a judgment. Okay. Yet they've been compensated $15,028 of what they claimed the settlement they came to of 34,000 when they were hired. Yet they were fired because they breached that contract. They were supposed to work in my best interest, yet they never did. Okay. So when I hired them, most of the work was already done. I've supplied them every single piece of evidence that they have in my case. Chris Brown said that Spitz has 200 documents, and Brian Spitz said the same thing. Well, those 200 documents are my documents as a direct result of my own work, okay, my own pre-litigation research, okay, my own efforts to ensure I sent letters out demanding that I get my personnel file and all my associated employment demographics, my uh, contact information and updates relative to the investigations that were going on, the investigators' contact information, such as that with OSHA whistleblower Trevor LaFleur, and there's another guy, Mr. Harrison, I think. With that, also House Civil Rights, Carol Scott, also EEOC mediator, Salvador Lopez, who Salvador Lopez told me that he actually knows Greg Schumacher personally, which might be the reason why during the mediation hearing, Salvador Lopez, EEOC mediator, and Richard Diageo tried to trick me, and they tried to actually put in an EEOC agreement, initial agreement, that 15,000 of my overall confidential settlement amount would be paid to Spitz Law Firm. However, I caught them with that. And I said, you cannot do that. It's not legal because there is no charging lien against this settlement. I'm representing myself here. And Aetna CVS, as well as Richard Diageo, Lindner Mendelsohn PC, EEOC, Salvador Lopez, all knew that Spitz Law Firm had been fired prior to the EEOC mediation. The EEOC mediation hearing was October 14 of 2022. I fired Spitz on September 25th of 2022. Trisha Breedlove put a withdrawal on the U.S. District Southern Division 2:2202519 case on October the 3rd. That was it for them. They were done. At that point, Spitz Law Firm had no legal binding settlement agreement in place. They had absolutely nothing. They had not seen any contingency types of efforts towards litigating a matter on my behalf to the end that resulted in a settlement. So they have been paid $15,028, which is 40% of what they claim they settled for. But that's imaginary settlement. It doesn't exist. They cannot and will not produce any type of paperwork that has my signature on any type of settlement where it will warrant a $15,028, 40% payment to them for legal fees. This is a crime and it is theft. Okay, so they were fired. So the only thing that Spitz Law Firm would actually have at that point of being fired would be an assertion of indebtedness. The only thing that they could say is, listen, she owes us for services that we rendered. And they would have to go into court and then sue me and then have a burden of proof and prove by what way do I owe them X amount of dollars and demonstrate their actual work and let a genuine calculation of fees be determined where I would need to pay them. Okay. And they know that, and everybody knows it. And so does Chris Brown, Littner Mendelsohn, Richard Diage. Everybody spits everything. They put this together by way of utilizing their legal knowledge and expertise to actually abuse and misuse the court system to make it seem as if the interpleader actually applied in this instance when it really does not. Okay, so Spitz Law Firm could insert an indebtedness. That's all that they could do, as if they are a creditor. And they could say, April Clark owes us XYZ amount of money. Then they need to sue me and they need to come to the table and let someone third party take a look at both sides and determine genuinely how much I owe them, which is not 15,028. Again, they've only put in a motion to stay and a motion to withdraw. I mean, how much does that cost? Okay. Now, Trisha Breedlove claimed I hired him on July the 19th, 2022. I spoke with somebody named Nick Kerr. Basically, you don't really hire them. They decide if they want to take your fucking case. I participated in his intake questions. At that point, he knew that I had already filed a federal lawsuit. And he asked me, why did I do that? Because they usually file those here in the state. Of course they do. They file it here in the state because they got linkages and stuff like that, and everybody's butt fucking each other and friends and everything like that. I filed in federal court because that's where the whole damn law stems from, and I can. Okay, but that's neither here nor there. And he said, "Oh, well, we normally file the EEOC and civil rights for our clients." Yeah, but I had already done all that. They didn't do shit for me because actually, when you filed the EEOC, the dual filed a damn civil rights charge, but I had filed another civil rights charge on top of that, and I had my OSHA whistleblower retaliation. Spitz Law Firm did absolutely nothing for me. Point blank, period. And Chris Brown is a liar. So people do not vote for him again. He is a liar. Okay. He has no integrity at all. And none of these lawyers do. And a man with no integrity is not a lawyer. All right. So they need all disbarred and put in jail. All right. And it'll be left up to you, public, because right now they're trying to conceal the EEOC settlement agreement that is the underlying fundamental basis of the interpleader. And it actually outlines the material facts to where someone objectively can be looking to say, okay, that does really say that you were supposed to pay her everything. That's a whole breach of that EEOC. I mean, and who gave you guys the right as the alleged tortfeasor to hold on to that property? The general release actually says that CVS Health Aetna Resources is supposed to send the entire confidential settlement amount of money to their attorneys, who would actually be the genuine third party without any interest or ownership in the funds. CBS has absolute interest and ownership in the funds because it is their money, it is their revenue. Okay, and they kept it in hand the entire time. The EEOC actually knew this as well. Thomas Coughlin of Washington, D.C., Jamie Williamson of Philadelphia, Dylan Gockow of Cleveland, Anissa Perez of Cleveland, Sabrina Austin of Cleveland. They all knew this. They all knew that CVS Aetna still had my money in their hand, 15,028, which was less than the overall confidential settlement amount, in which they agreed in writing on October the 28th of 2022 to release to me and me solely as the charging party of 532-202202-705 directly in total entire sum. And that check was to be split up into two checks, one for past wages and the other for the pain and suffering. Okay, so keep that in the back of your mind. Then I'll tell you exactly why the interpleader came about. The interpleader came about because of the actions and the wrongdoing and the mistake of Richard Diageo of Littner Mendelsohn PC that he did. Okay, so he's caused his own liability, his own business's liability, his own colleague, Alex Frondor's liability, but yet they tried to go and file a fucking interpleader in a damn court as a whole total bill of peace and get off scot-free and not have you know anything about the actual theft that took place because they're actually in cahoots and collusion with the head person in charge who abused discretion and abused power, and that is Chris Brown. And it's intentional, it's deliberate, and I still am being harmed because Brian Spitz of Spitz Law Firm has my money at 15,028 in hand that he did not earn. It is illegally in his hand. He has stolen property in his hand right now, and he cannot show at any point or demonstrate any actual work where he contributed any type of labor that's commensurate to any type of time spent working for me on my behalf in any type of cause of action that resulted in any payment of anything. Okay. He doesn't have any expenses fronted. They don't have a charging lien. Okay. Even if there was a damn charging lien, the case is dumb anyways, because in an interpleader, a charging lien follows a fund. Okay. It doesn't follow the person. And these are lawyers. Who the fuck gave these dumbasses a damn law degree? I'm not a lawyer. Okay. So there is no charging lien. First of all, you ask Spitz, you would have to assert a charging lien. Then you would have to send me notice of the charging lien. There was no notice sent. If there's a notice sent to let Trisha Breedlove, Greg Schumacher, Brian Spitz, Nick Curry, anybody at Spitz give you the certified mail receipt, green card that they notified me of a lien attachment to any future settlement that I ever got on my behalf. After I fired them. They don't have it. This is theft and it's grand theft. The police know it. I've turned all these people into the Columbus Police Department, Cleveland Police, New Jersey Police, New Jersey Board, Disciplinary Ethics Board also knows about Richard Diageo and they have done nothing. Yeah, so U.S. Marshals know, everybody know, everybody, and nobody's doing anything. Sheriff Brown's office knows, Joyce Beatty's office knows. Like I said, EEOC Dilla Gakau and Lisa Corellas called me over the phone and told me to go ahead and put another retaliation claim in against CVS because of this. And I did. And then they all got in cahoots with these lawyers or whatever the hell. And then they conjured up some lie talking about in Ohio law, as long as Aetna doesn't have the money in their hands, EEOC doesn't see it as a breach because they set it aside and put it in the court registry. However, Thomas Cockwell wrote that, and he knew at that particular time that Aetna Resources LLC still did have my money in hand and actually had not set it aside, and it was not in a court registry at that time. So that was his sole reason and cause for stating that the EEOC itself would not enforce the MSA, even though they really knew it had been breached. They claimed because it was set aside in a court registry, the money, they didn't see it as a breach, but they knew that that was a lie. They were just writing that so it looked good on paper. And we now have proof, and we know that it was a lie because what? Because CVS Health just cut a check to Brian Spitz Law Firm, which I have a copy of that Richard Diageo of Littler Middleton sent me, that shows that CVS Health Pharmacy is what it says, cut a $15,028 check directly to Spitz Law Firm. The invoice was on the check stub is for November the 3rd. The check is dated November the 7th. Yeah. Okay. So they held onto my money the entire time. So EEOC is also very discriminatory. They pick and choose who they want to enforce their own MSA agreements with or for. Okay, Aetna is a tortfeasor. They held the money in hand. They never put anything in a court registry, never interest bearing account, no escrow, no nothing. Chris Brown ignored the actual motion that Alex Rondor put in to put it in the court registry. Okay, but yet and still there is no lien whatsoever. There's no attachment. No lien was ever perfected. Spitz Law Firm knew exactly what they were doing because Richard Diageo already came over and told them that they told him. I got it all in email that they know that they're not going to be able to get their fees. Well, why wouldn't they get their fees? They wouldn't get it because they have no actual work. And in a true case that's actually adjudicated on its merit and done correctly, that's how it's done. The person, the law firm will have to come in and show their actual work, and it has to be commensurate with their education and legal expertise and things like that, which they have nothing. They didn't litigate anything. There's no litigation that took place, period. There's no negotiations that they did that took place. There's nothing at all that they did that resulted in a judgment or a settlement on my behalf. That's absolutely true. It's factual. There'll be nothing that anybody could say or do or show to rebut and refute that. That is fact. So why the fuck does Spitz Law Firm, Brian Spitz, have $15,028 of my motherfucking money in his hand right now that the racist CVS Health, Aetna Resources owed me because of a race discrimination and disability discrimination, EEOC to Ohio Civil Rights, OSHA whistleblower retaliation case have been filed. Excuse me? That's what I'm trying to find out. Where's my money? Okay. And Chris Brown covered it up. And he wanted to make sure no jury had the opportunity to come in and hear both sides, nor award any type of damages or slap any punitive damages on these fictitious litigators, or create any type of public record or case law that's a hands down win in a situation like this, and have it be revealed that CVS Health and the resources had been charged with racial and disability discrimination, that I had been actually fired wrongfully for participating in during the time I was participating in protected activities under a federal law, um, grounded in Title V11 of Civil Rights Act of 1964. And they're still trying to keep that information from you. Okay. So what I need everybody to do is pay close attention to Columbus, Ohio Court, Franklin County Court of Common Pleas, 22CV007866, 22CV008947, and also 22CV008936, with the latter being the presiding judge is Michael Holbrook. There are motions and things like that on the record right now. One is to unseal the EEOC mediation agreement so that there is transparency for the public. You have the right to know the whole amount. You have the right to know what's in the verbiage, what's the conditions of that particular agreement, so that you can understand the entire case, the situations involved in this case, and why Judge Chris Brown would have ruled in the way that he ruled. So you can also see the deprivation of rights under cover of law. That's what they don't want you to see. All right, so please keep an eye on that. It should be unsealed, because at this point it needs to be. It's wrongdoing. It's illegal and unethical actions of the judicial system going on. Your taxpayer dollars have been increased substantially by the acts of Alex Frondorf and all these people. They filed this frivolous thing in the court, and they use your tax dollars behind the bullshit. And I've actually been harmed, and I'm continuing to be harmed right now today. I'll never shut up and stop talking about it, because it's true. And I feel like a slave. Someone just came along and took everything. I have no life. I have no liberty. I have no property. I have no pursuit of happiness. I have no civil right, no human right, no constitutional right on a US level or a state level, point blank, period. All these white people are racist. All they did is started at the job. They're racist employees inside the job. The business itself protected them, got rid of me, and fired me without cause, based on the fact that I brought the awareness and I was participating in those protected activities to do so. And then they came to the table and they said, yes, we know that you fired Spitz. We know about this fee dispute. We know there is no charging lien. We know there is no lien whatsoever. But yes, we are willing to come to the table with you and you alone, solely as pro se, representing yourself, with the prearranged mediation hearing that you had already set up prior to even hiring Spitz Law Firm. But Chris Brown lied and said that Trisha Breedlove had set up that meeting. Chris Brown is a real liar. He's a whole demon. I don't know why any of you would want him to be a judge over anything. He is an absolute liar. He lied line for line for line in the ruling in 22CV00 7866 and 22CV008947. He literally just lied. He made up his own story. It's no truth to it whatsoever. Okay, so Spitz never uploaded any documents into the EEOC portal. They were not there. Okay, they were fired. Remember, September 25th, they withdrew October the 3rd, and then Trisha Breedlove sent a letter over to Richard telling him that she withdrew and that I was planning on going through with my EEOC hearing. All right. So if Spitz, they had every opportunity, if they wanted to perfect a charging lien. Okay, there's processes involved in that. I mean, they're lawyers. They don't know that. Yes, they do. But instead of doing the right thing, what they did was they found a way to commit a crime, which is conspiracy to commit theft, to get a hold of my money that they claimed was 40% of a settlement that they got me. They never got me a settlement, okay, that they can ever prove 15,028. Okay, if you go ask them, this 15,028 is 40% of what? They'll tell you of some imaginary settlement that they got for me, all right, by so-called negotiating. When they got hired, I talked to Nick Kerr, did an intake. Then I talked to Greg Schumacher about July 24th or so. He said he was sending a demand for settlement letter over to CVS or Little Medicine or whoever for $80,000. Still to this day, here it is December 2023. I still don't know what CVS Aetna said about that demand letter. I still don't know. Okay. I have not been given any type of opportunity to rebut or refute anything that CVS or Aetna was saying, but with any so-called negotiation. So I'm just trying to figure out, how the fuck does Spitz Law Firm even come up with some type of a settlement? I don't understand that. It's because they didn't do shit for me. They're just looking to get 15,028 and make it look good on paper that they got something for them. It's not for me. And I don't have to accept no fucking settlement or agree to shit that I don't, that I'm like, y'all motherfuckers, you're not working in my best interest. That's a breach of contract. I don't have, I can go ahead and do my federal case and my other shit, and not have them do anything for me. Yes, I can. Yes, I absolutely can. But if you think that I owe you for some services that you rendered up until the time I fired your ass, then bring in your actual work and then you'll get paid, for that. I don't have a complication with that, but that is fair. They're not trying to do it fair. They want $15,000 of my money. Okay, so from July all the way to September, I never talked to nobody. September the 13th, I get an email from Trisha Breedlove saying that, from the last time that we had spoke, I told her something about where I was working. So she was following up on my employment status. Do you know I had never spoken with that lady ever in my life? So that's why these people need to be investigated and audited too. They're sending out emails and shit like that to their clients that it appears on paper that they've spoken to them before and they built a relationship where they're communicating with them, but it's not true. I had never spoken with her ever prior to September the 13th email where she outreached me asking what my employment status was. So I replied to her in email and I have all this evidence. It's all in email. I said, I don't believe that I know you or ever met you. Um, who are you? And she's like, but didn't you tell another attorney or another lawyer here that you used a DoorDash? I said, well, I'm responding to you the way that I'm responding to you because your email made it seem as if I had spoken to you prior about something. And I've never spoken to you nor met you ever before. She replied in email, which I have. You're correct. I never have met or spoken to you before. I'm using the file of information that you told another attorney. The file that she's talking about is the intake file questions of what Nick Kerr was asking me. Okay. And if she had any privy to the work pro say work product that I sent over there, that's what she claimed she was utilizing. She said, I'm utilizing that to negotiate your settlement. What type of negotiations do you know that don't involve back and forth, rebuttal and refute? Who is she negotiating with? Herself and Leonard Mendelsohn? That's what she's doing. She's talking back and forth with them to get herself a settlement because she never ever touched base back with me and told me jack smack shit that CVS, Aetna, Littner Mendelsohn, Richard, Alice, anybody was saying about anything post the demand for settlement letter in the amount of 80,000 that Gray Schumacher said back in July he sent over to them, which I don't even know if he ever even sent that shit. They probably lying about that. I don't have no copy of that. Could you please produce that, Brian Spitz? Let me see that letter because I don't know. CVS, what the hell did you say about that? Because I have no bad performance reviews. I have no policy violation. So why wouldn't they pay 80,000? Okay, so I would need to hear why they wouldn't pay 80,000 so that I could rebut and refute it because I don't have anything. I've never done anything wrong and they can't prove it because it just doesn't exist. Okay. Again, this is racism, it's retaliation. Yeah, and now it's turned into grand theft of property, and things like that. And all these people need to be in jail. So basically, after that, I fired them. So I fired them after finding out the bullshit that was really going on. They never communicated any damn thing to me, point blank period. So they were fired. And Spitz, like, no, what do you call it? Let me remember from PC have full awareness, Richard Diageo, EEOC mediator, Salvador Lopez, that I intended to sue Spitz Law Firm for malpractice and negligence, because they really didn't work in my best interest. Aside from that, that's over. What Spitz has done. CVS Aetna agrees to go ahead and come to the table, clean slate, and let's negotiate. We negotiated a settlement. It was just me by myself, the mediator, and then the ex-employer. We came up with the confidential settlement amount. The initial MSA agreement had in it that it was going to pay Spitz Law for 15,000 of my overall settlement. I said, I am not going to sign this. I'm not going to settle via EEO MSA if that language remains in this particular agreement. So Richard Diageo and Salvador Lopez of their own free will voided that out. Richard Diageo, he told me, he said, I understand your position. I have it in email when I told him my reasoning behind it. Salvador Lopez, I have it in email, says, I apologize. It's just a miscommunication. It's easily fixed. And Salvador Lopez sent out an email to all parties present at the actual EEOC hearing stating that Ms. Clark has notified us that she refuses to sign the EEOC MSA agreement or come to any agreement if the language remains the same, allocating Spitz Law Firm $15,000 of the overall confidential settlement amount. And he said, we will take the language out. If you guys are unable to come to an agreement, then we'll just return it back to the EEOC for the actual continuance of an investigation, because I said I'm going to follow through with my federal case. I said I'm going to report all of you to the federal judge of what's going on here. All right. So they voided it out. But here lies the complication. Richard Diageo had already went over to Spitz Law Firm Trisha Breedlove and told her he had a check already for $15,000. He said, listen, I got it. We have a express settlement agreement in place. Let me get your W-9. So she just thought, okay, everything's said and done. I'm getting 15,000. All right. But what Richard Diageo never did do was go back and tell Trisha Breedlove that, in fact, I caught him and the EEOC mediator trying to put some shit in there to pay them when they didn't do any actual work, number one. But number two, they didn't have an actual lien on my settlement that I just got by representation for myself and negotiations for myself by my own hard work and labor, right? Yeah, he never went back and told them that. But then he turned around and sent them an email, which I have, that said CVS Health intends to send $15,028 to April Clark as it is part of the overall technical EEOC MSA agreement. So he knows it's part of the overall confidential settlement amount. He also said that is due to her an entire sum. He notices that too. He knows that it's due to me and it's to be paid to me directly. And he told Trisha Breedlove that it would make no sense for Spitz Law Firm to try to sue him or Aetna because you can't sue him or Aetna because the tortfeasor has to pay me all of my money as it's outlined in entirety and in full. And if they have any fees, Spitz, then Spitz would have to come after me directly. So they know exactly what they're doing and they know exactly what the law says. They were just hoping that I wouldn't know so that they could get away with this bullshit. Okay. But surprise, surprise, right? Mm-hmm. So anyhow, yeah, so Trisha Breedlove and Spitz Law Firm just basically replied back like, yeah, no, you told us you hadn't expressed contract. You was giving us 15,000. You asked for the W-9. You never came back and told us that you voided that out. You never told us anything. Now all of a sudden there's no agreement. And he said, well, Ms. Clark repudiated that agreement. He still didn't accept responsibility. It is an actual repudiation of the actual agreement. But why wouldn't you just accept responsibility? Richard Diageo, Littler Mendelson, PC, New Jersey. Why wouldn't you just say, well, I actually voided that out because she caught me and Salvador Lopez trying to write in the payment to you guys when we know you don't have a charging lien and you don't have any type of judgment or anything whatsoever legally binding or anything that gives you the grounds to have any of her money. So that's why we took it out. He never did that. So what they did, they threatened to sue him individually for his personal assets and also Alex Frondorf individually for his personal assets and also his firm, and then also CVS, and then also Aetna as well. Okay. So Richard Diageo, he sent me an email, honey. Okay. I have it all. And he asked me for my consent to hold my $15,028 in a trust in his office. And I told him no. He said, because Spitz Law Firm had threatened to sue him individually, Alex individually, his law firm, Littler Mendelson, CVS, and Aetna, if he did not figure out a way to come up with an agreement over the $15,000 dispute between me and Spitz. He wrote all that out, and I actually have it. He said, and because they don't believe that they can get their fee, they'll be able to recover their fees from you. He wrote all that out in an email, and I have it. Okay. And I put that email actually in with the court. And it's actually still evident. When the court's record went over to Court of Appeals, that email itself is still open. I mean, so the Court of Appeals will be able to see it and read it. And I actually think the other one is open as well that says the CVS was going to give me my money, and then where he wrote that as well. So he basically told on himself. Now that part wasn't sealed. I think Chris Brown did tell the clerk to seal that email, but everybody's so disorganized and fucking incompetent. They didn't actually seal it, but thank you, Jesus. Thank God they didn't. See how God works? You keep doing wrong and lying and stealing and robbing and shit like that, it's going to come to light. Wrongdoings come to light. Yeah, so the appeals court will actually see that. Yeah. But what's our issue now is we really need to open up that EEOC agreement so we can see what it says, how much it is, and everything. Because 40% of what I got is not 15,028. First of all, okay, and also we want to know what calculations were actually performed for Spitz Law Firm to end up with 15,028 property. For what again? You don't even have a settlement in place. What that's it's 40% of what? You don't even have a settlement. It's not 40% of my actual overall confidential settlement amount. So we know that that's not where it came from. And we know that if you're claiming that you have actual work and I'm claiming that you don't, then you have to bring it into court and you have to prove it. And then we determine how much you get. You just don't automatically get 15,000. You will automatically get 40% of a contingent contract if you actually poured into it. All right. And that your work and your labor, your educational expertise, all right, your pre-litigation research, your filings of motions and pleadings and claims, okay, your court costs and all this, your gasoline, your postage, your copies, your scans, your faxes, okay, yeah, your deposition, your discovery, your evidentiary work, all right, your time that you spent interviewing witnesses and all this type of stuff, the time that you spent speaking on my behalf as a representative for EEOC or OSHA whistleblower or a Hall Civil Rights, all those types of things. Yeah, they have a dollar amount associated to it, but Spitz Law Firm never did any of that. Nothing, zero. And they won't ever come and tell you that they did, point blank, period, because they don't have shit. Okay. Now, Brian Spitz did come to me and email, that common email thread with Jacqueline Bajas. And he offered me $1,000 to drop all my charges and all my claims against him, Spitz Law Firm. He said that, he has no intention on bringing any defamation or anything like that against me and all this type of stuff for whatever misrepresentations, but I haven't misrepresented anything. Everything's true. Okay. I haven't, this is not slander. It's not libel. It's not any fucking thing. Defamation. It's all true. Okay. Now let them go ahead and come say something otherwise. That's fine. They can't prove shit. I'm telling the truth. These motherfuckers stole my money, period. And Brian Spitz has it in hands and he won't give it to me. But I turned them all into the IRS and I asked the IRS to do an audit on each and every one of them individually and also the associated businesses like Spitz Law Firm and also Littner Mendelson, CVS Health, and also Aetna Resources LLC, because nobody would tell me where my money was. Nobody would tell me where my property was. I have every right to know and have communication relative to where my property is located. If it's in a trust, I need to know what bank. I need to also have the complete transaction history of deposit and any transactions of withdrawals or anything like that specific to that trust account, escrow, IOMTA, fiduciary duty, fiduciary title type of a deal. Yeah, but they don't have it. There is not one. That's why they kept ignoring me. Okay. And the only reason why they responded is because I let them know that I had turned them all in to the IRS. I did a W-4 sandwich on each one of them. And I did a cover letter outlining everything that has happened here and that it's a crime and that I would like them all to be audited because nobody would tell me where my property was, but yet my overall income for this coming up tax year has been debited negative 15,028 for disputed claimed legal fees. Okay. I can deduct legal fees from my income, but nobody is really giving me like an itemized invoice of where these charges are coming from, nor a receipt for now that Spitz Law Firm Brian Spitz has $15,028 in hand. I don't have a receipt for that yet. So I have to make sure that the IRS has the awareness so that when I go and I report my taxes that I'm doing the right thing and I'm getting my appropriate deductions in place and that the IRS goes and checks each one of these people to find out. When I put the W-4 and all that in, I didn't know who had my money. But miraculously, once they got the awareness of that, and I did send a certified mail, and I have all the green cards back from that they all do have it, telling them and demanding that I need my misappropriated property released. So that's when Richard Diageo sent a letter with a copy of the check that CVS Health Pharmacy created. An invoice for November the 3rd, and then the check is dated November the 9th that was sent to Spitz Law Firm. So that's directly from the tortfeasor's actual income and revenue to individual, which none of these people had the right to seize my property, gain control over, and do whatever the fuck they wanted to do. No lien was in place. And if there was a lien, there needed to be a trust securing my funds. They never safeguarded my funds. It's a breach of fiduciary duty. It's actual theft. And this is a crime that all of these people were involved in. From the onset, it was a conspiracy to commit felony theft. It's a money heist. Okay. And all of these individuals use their legal knowledge and expertise and legalese, and they even put case law and all. They made it look real good for the public to deceive you. It looks good on paper, but once you learn the material facts and the underlying tribal details, of course, then yeah, you begin to look at things differently. And here's the reason why they don't want the public to know anything. And as you can look at the ruling for Chris Brown, he's sealing everything because he doesn't want you to know, public. And then I don't know what Michael Holbrook is doing, but I just put something in on 22CV008936 and requested that, of course, I would like for that to be unsealed. So to keep an eye and watch and see what his decision is in that particular motion, you have an actual right as the people of this particular state, payees or payers of your taxes and voters and everything else to know what's going on. And you need to know about this. It can happen to you. It can happen to your loved one. Anything like this. And these are rogue, lazy judges. Okay, and bad apple attorneys in Ohio that their disciplinary board knows about, everybody knows about. Yeah, and nobody's doing shit about it. So there's no telling how many other people they've done this to. And any summary judgments that Chris Brown has ever put on anybody, you need to go and pull it. You need to audit, especially if it's on Black people, because he doesn't like Blacks. That's why he got into that role that he's in, so that he can keep his foot on all the Black people's neck, get to deprive their rights under color of law. And I guarantee you there's a lot of Black people that's sitting in jail right now because of Chris Brown. He done spun a narrative. He's covered up some type of real evidence, didn't let the material facts, the tribal facts in, and he's just he is a demon. He needs to be off the bench, period. Yeah, so the sooner the better. And everybody keeps ignoring this shit, but it's true. I need to know where my fucking money is and when all these motherfuckers gonna get arrested. Because if I had done something like this, the police would have been knocking at my door. I would have been arrested. I would have been under the fucking jail by now. No one is above the law. I want to know when Brian Spitz is gonna get arrested. I want to know when Trisha Breedlove is going to get arrested. I want to know when Richard Diageo is going to get arrested. Okay. I want to know when Alex Frondorf is going to get arrested. When are they all going to get arrested? When Chris Brown going to get arrested? Any and everybody that's on any of these associated cases, 22CV007866, 22CV008947, 22CV008936, that all work for Little Mendelson PC, CVS Health, Aetna Resources, Spitz Law Firm know about this. They all need to be arrested. Anybody out there at EEOC, Thomas Cocklaw, Jamie Williamson, Dylan Gockel, Nanisa Perez, Sabrina Austin, anybody that knows about this and didn't do shit needs to be arrested. I contacted Joyce Beatty's office about this as well. Someone named Larry Seward sent an inquiry over to EEOC. EEOC sent back whatever bullshit they had, which was not true, saying that Aetna don't have the money in their hands and it's in a court registry, saying they did an investigation. Well, if you had done a true research and an investigation, you would have clearly known that Aetna didn't put the money in a trust, escrow, a court registry, and they still had it in their hand, and you would have enforced your fucking MSA agreement in 532-202-202-705, okay? So they all know about this shit, okay? Salvador Lopez knows. So why can't I have a jury trial? Well, they don't want you to have a jury trial because on my witness disclosure, I have everybody listed that I can call in. And these people will have to come and speak under oath and tell the absolute truth, the whole truth and nothing but the truth. So that's why Chris Brown ensured that they weren't able to do that. He ensured he revoked my right, my 14th Amendment right, and my opportunity to come in and be heard, to come in and confront individuals, to come in and cross-examine individuals, to come in and ensure that this particular matter was adjudicated on its merit. All right. So let's go over the statement of issues. All right. That is, all right. This is what the appeals court is looking at. They have accepted my brief. They're looking at the trial court error when it found a summary judgment in favor of Spitz Law Firm when the record presents genuine issues of material fact and demand resolution by the tier fact. Did the trial court error when it awarded 15,028 equitable property of April Clark to Spitz Law Firm, knowing it has no legal binding settlement it contributed to due to termination of attorney-client relationship prior to the EEOC mediation hearing October 14, 2022, where appellant, that's me, represented as pro se litigator? Did the trial court err when it, under assumption that appellee Spitz Law could prevail by not requiring appellee Spitz Law Firm demonstration of actual work demonstration and evidence without a starting point in setting fee award or consideration of actual work commensurate to time spent? by Spitz Law Firm in absence of any expenses fronted or incurred, right? Because there is no expenses fronted or incurred by them, and there is no charging lien assertion. There's one asserted. There's no attachment. Right. All right. So also, and notice there to appellant or attachment to the EEOC MSA and general release settlement where Spitz Law Firm did not represent or demonstrate actual work related to the EEOC MSA and general release settlement agreements or any litigation, nor Spitz Law provide declarations of any kind illustrating how attorney education and expertise applied to the EEOC MSA settlement and general release or any case, and or filing of support for fee demand with documentation of time expended on lawsuit or charges, calculations noting or encompassing eligibility, entitlement, and rationale for the calculations, right? It doesn't exist. It doesn't exist. Did the trial court err by disregarding the legal status of the U.S. Equal Opportunity EEOC MSA and General Release Settlement Agreements under Title V11 of Civil Rights Act of 1964 and allowing illegal seizure authority of alleged tortfeasor appellant Aetna Resources LLC CVS over equitable property owed to appellant while allowing appellee Spitz Law Firm to be distributed directly from alleged tortfeasor revenue versus preserved fund? Okay, there needs to be a preserved fund and an interpleader, which it wasn't. My money was stolen any fucking way. Did the trial court err by permitting improper interpleader? It's an improper interpleader to begin with. The rightful owner is actually none. And the EEOC MSA agreement is what they want to keep hidden from you because it illustrates that. They also want to keep hidden from you all the emails and back and forth and stuff like that. Richard Diageo and Trisha Breedlove and everything like that, where they basically admit and confirm knowledge and awareness of all the shit already prior to even going on and filing this interpleader. The reason why the interpleader was filed is because Spitz said, we're going to sue you, Richard, individually. You need to come up with something. So they devised a plan. All right. They thought about a story. How can we use the legal system to get out of this shit, basically, right? So also, did the trial court err when it abused discretion and deprived U.S. constitutional rights under color of law and disregard of appellant claims as a matter of law? Okay, yes, it did. Did the trial court err by ignoring pending motions on the case record for filing date of November 9th of 2022 until November 27, 2023, summary judgment ruling email of Jacqueline Bajas, including motion to deposit funds into court registry? I got the email from Jacqueline Bajas on October 27th, but the case record will show that the decision came out on the 31st, okay? But this Ohio Appeals Court 10th District would not allow, they denied my motion to add that email thread with Jacqueline Bajas.
Take this walk.
Walk, all right. You going to the Y? You can go to the Y if you want to be inside.
No, I don't want to get inside. We can about walk around guys.
All right. Yeah, they said I couldn't put this in when really it should be put in because it attaches to the case record and it has material facts in it because we're discussing things back and forth. It shows how there was true concern for my rights in there. It shows how there was true concern for why these motions continue to be pending. And Jacqueline Bajas saying even back in February 2023 that the court was moving on the motions, but they never did. All right, this is corruption. This is cahoots, it's collusion to commit grand theft of my property. All right, so this is basically the background, all right? For the court to understand the conspiracy against April Clark, which includes alleged racial and disability discrimination by alleged tortfeasor Aetna Resources, grand theft of property, improper interpleader filing, seizure of equitable property without implied or express consent, breach of fiduciary duty to safeguard misappropriated funds, breach of contract, malpractice, misrepresentation, frivolous conduct, breach of EEOC, MSA settlement, and general release, trial court abuse of discretion, deprivation of rights under color of law, and continued victimization and harms to April Clark. These facts are delineated, yet not in exhaustive list of detail. The doctrine of unclean hands is applicable in this matter now in pendency before the Honorable Court. All right, so Aetna Resources, which is CVS, all right, they filed an interpleader cause of action on the 9th of November. All right, I filed my answer on the 13th. Then, Spitz did their cross complaint and their answer or whatever. All right, it was so many motions and pleadings and briefs. Spitz Law Firm even asked for sanctions on Aetna, all kinds of stuff. And yeah, so I'm gonna try to go through it quick, but because I've already pretty much told you most of this. Okay, yeah, I told you I was hired as a CVS nurse. I learned that I had been terminated by Darcy Gay on a voicemail and through a email notice while I was participating in protected activities under the Title B11 of the Civil Rights Act of 1964, employment discrimination. Yep, protected activities that related to race and discrimination, disability, and my OSHA whistleblower on retaliation. I hired Spitz Law Firm to intervene and take over the pro se litigation of the U.S. Southern Division Federal Case 2:22 CV0219 on July, what's the name? I already told you guys that. I terminated them on the 25th. Trisha, she withdrew on the 3rd of October. That's just more information about the actual case. Yeah, I said that they had been fired before the hearing date, which I already told you. Yep, and then we went back to the table, the EEOC mediator, he outreached CVS and said, hey, you're gonna just come to the table with April Clark as pro se by herself and then just do it like that from the very beginning. They said yes. So that's what we did. Okay, I did that all by myself. Okay, so I also said Spitz Law Firm played no role in gaining the settlement payout as a direct result of the labor of appellant April Clark as pro se, yet has reaped 15,028 of her known equitable property illegally. Spitz Law Firm has reaped fruits of labor. It did not provide in negotiations and settlement where appellant April Clark represented herself as pro se and negotiated settlement by way of her own labor. All right, so the EEOC meeting was October the 14th, it was scheduled prior to Spitz Law Firm being hired, okay? And which that could easily be confirmed by EEOC in cross-examination and real trial as well, like a jury trial. They could say, yeah, when did you guys schedule the hearing? Because they're the one that scheduled it. And you could see if it was prior to July 19th of 2022, which it was. All right, so it says that me as a pro se litigant, I've completed significant evidentiary discovery, pre-litigation research, interviews, and investigations related to my own, employment claims in totality. And when Spitz Law Firm was hired, I gave them personnel records, the demographics, and all that was inclusive of that. Correct. That would have had performance appraisals, corrective actions, or disciplinary actions. I don't have corrective actions or disciplinary actions. And at the time that I was fired, I only had one performance appraisal, but it really wasn't even that because I hadn't really been there that long. I didn't have anything bad. Any other retaliation or discrimination reports to Human Resources, the Compliance Department, and any chain of command, employee relations, ethics point where you have to report, things that's going on. I gave all of that to Spitz. They never did any work of their own. Okay, so I told them about the contact that I had with Littner Mendelson and that was the counsel. I gave them all that information. I gave them all the investigator information related to the EEOC, the civil rights, the OSHA, they did nothing on their own, okay? So I basically solely and exclusively interviewed all my investigators. I uploaded, scanned, copy, fax, mail, all my documents and evidence. I paid for the postage. I paid for my gas. I'm the one, okay? I filed all my motions, pleadings, and associated briefs, exhibits, and as pro se. Okay, Brian Spitz, Trisha Breedlove, Greg Schumacher, Nick Kerr, and nobody at Spitz ever did any of that shit for me. Never. Then they won't be able to show it. Period. Okay, and all the aforementioned matters from initiation of employment discrimination cause of action, each and every claim and charge. Okay, I said I didn't incur any court fees and costs because I filed the affidavit of indigency. So Spitz would have no fronted costs because that was the only case that charged the cost, and that's the only one that they put a motion to appear, a stay, and withdraw on. That's all they've ever done for me, nothing. But they got $15,000 of my money. I find that to be very odd and suspicious. Okay. Yeah. So, anyways, I said that neither did Spitz Law. They didn't have shit. Okay. So neither did Spitz, but Brian Spitz tells the court that he had fronted costs. Where we like to see him. April Clark incurred significant costs associated with the pre-litigation research, travel, copies, faxing, and other administrative costs during litigation, and spent countless hours laboring as pro se to litigate the matter. Now before the Honorable Court, April Clark provided Spitz Law Firm Nick Kerr, Grace Schumacher, her pro se work product, inclusive of substantive evidence obtained during employment specifically related to termination, court claimant charge filings, as well as witness information, investigator contact details for EEOC, civil rights, OSHA. Further, all evidence received post demand letter for employment or personal unrelated documentation with notice to CBS Special Counsel Karen Gaster, Richard Diageo contact information. Basically, I just gave all the contact information. Let's see, can I move this? Let's move this. Spitz Law Firm did not act with due diligence, which they didn't, and has no actual work of its own by way of any form of representation on behalf of April Clark post hire through termination date, which is true, and they won't be able to prove it. I'm not telling the lie. Spitz Law Firm never helped me perfect a settlement that paid the confidential settlement that's inclusive of the $15,000 that they seized, that CBS actually seized without consent. Okay, all right, buying through its counsel. Right, because the council got an interpleader trying to make it seem like they have a right to have it. Okay, like they don't know the rightful owner and all this bullshit. It's a lie. All right. What else? What else? I've already told y'all pretty much most of that. Yeah, so yeah, no, I'm just basically saying here, Leah, but Spitz Law Firm hasn't handed my equitable property in the amount of 15,000. Yeah, never paid entire, that was never paid an entire sum as this particular settlement and general release actually do read. The general release and the EEOC do not read any differently relative to the disbursement of funds. The only difference is that the general release says that Littner Mendelsohn will do what is in accordance to the law as far as the 15,028 is concerned. But as you can see, they did the exact opposite. The law would have said that you would have had to give me my property, right? But you didn't, so you broke the law. Okay, we basically already said this. Okay, so I just said here, just like I told you, April Clark's surprise, I never received any reasonable communication from Spitz Law Firm, Nick Kerr, Trisha Breedlove, Grace Schumacher through the course of the client attorney relationship, right? Following hire date, Spitz Law Firm, April Clark, I spoke with Grace Schumacher on or about here to learn that they had the intention to send a settlement demand letter for $80,000 to Littner. Okay. But the next outreach, which I still don't know what they said. The next outreach was September, July to September. I didn't talk to nobody, right? From July to September. Then this person, Trisha Breedlove, I don't know who the fuck she is. She sent me an email talking about, hey, what did I say earlier? Since the last time we spoke, are you still working at DoorDash? Bitch, I never spoke to you before. Don't talk about what's from the last time we spoke. Read everything that people write. That's how they try to build their case. Because they'll go into a court as an attorney and try to make it on their timeline that they had actually been communicating with you. But that's a lie. I don't know who the fuck she is. She knows that she had been negotiating a settlement with Aetna. However, no attorney had ever outreached April Clark the update post demand for settlement letter distribution or a lot of opportunity for April Clark to rebut or refute position of Aetna Resources CVS at any point from hire date to termination. And see, in a real court of law, Littner Mendelsohn could speak to that and they could say, yay or nay, we ever got a settlement letter, demand for settlement, and what did we say in rebuttal to that demand? Okay, and then what did Trisha Breedlove come back to you and tell you that April Clark said? Like that. We need to know what was being said back and forth, back and forth, back and forth. That doesn't exist, okay? And also, I had to put in here that what CBS did, just to go to show you how low down dirty they are, they actually put in a employer position statement to the OSHA whistleblower investigator of a performance appraisal that was negative on a person that wasn't me. It was a 39-year-old Black woman who had got on the camera or something like that during a team's meeting with her baby, and she got reprimanded for that. And she must have said something smart out to him and all of that type of stuff. But that was not me. And that was done deliberately, that they would sneak that in there. I'm 50 years old. I was 49 when this went on. I don't have any little bitty kids, and I don't get on teams meetings and stuff with babies. I was never reprimanded, never happened, but they snuck that in to kind of hope that the whistleblower investigator accounted that as it being some type of poor performance for me. But why would they do that knowing they had to give me a copy of it? They thought I was going to go through the file, and I found that. I'm like, what the fuck? That is not me. These are just liars. These are bad people, folks. These are liars. All of these people are liars. Oh my God, I can't believe it. But anyways, I did tell Spitz about that. So the reason why I put that in here is because it's critical to know. Because once you know that somebody has put some false information on you and stuff like that, I have to know everything that Spitz Law Firm is saying. I mean, CVS is saying in a negotiation mannerism about me. I need to know that. So I said, no, that's not true. You know, they already put this thing in saying that I was this woman. I'm really not. So but Trisha Breedlove never told me the goddamn thing that these people were saying. You understand me? Never. These are liars. All right. So basically, what else did I say? Da, 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 da. Okay. So each party knew and understood that equitable property rightfully belonged to April Clark, including the trial court and its presiding judge, Chris Brown. Yet the litigation, misconduct, atrocious, outrageous, and egregious actions have continued today, which are a danger to the judicial process and have created further harms to April Clark. It is a danger to the judicial process. And that is why there needs to be transparency. And that is why you out there in the public literally have to know everything that's going on with this. Everything. Yeah, because these people are getting ready to go to jail. And so you want to make sure we're rightfully sending them to jail, right? Yeah, and we are. So don't worry about it. But I want to be fair and I want to say, let's make sure everything's out there because of what they've done, they're going to lose their license, they're going to be disbarred, and they're going to be in jail. So we want to make sure that the public knows, and then there's no problem. The public can really decide. All right, so they knew all of this, full prior knowledge and understanding that no charging lien attachment, court order, or judgment existed, nor applied directly to the settlement that I got, right? Yes, they did, boo. So this is all the abuse of discretion. So that's just some laws I threw in there. So anyway, Richard Diageo, he ensured that the general release that made me the sole exclusive owner and beneficiary. He took all the specific language out. He sent me an email that said, as you requested, I took all the specific language out, paying Spitz Law Firm $15,000. He said, I only put in there that I acknowledge the dispute. Yeah. He said, but I'm going to send you over my red line draft copy to take a look at, review, let me know if you approve it before my finalization. So they all know exactly what they're doing. I have all the emails. It's true. The trial court ignored the case record motions, pleading and briefs from the filing date through the judgment, which I already said. I have repeated myself in here because obviously motherfuckers not listening. Okay, I done told everybody about this shit, and these people are not arrested yet. On February 21st, staff attorney Jacqueline Bajas alerted all parties to the action that the court was moving on, the motions, and would alert if a status conference was warranted. Several months passed and no ruling on the motions were made. Okay. Thank you all. The court will move on the motions and will be in touch if any conferences are needed in the future. Thank you, Jackie. Despite the February 23rd notice by Jacqueline Baja, none of the motions were moved on. Then she sat up here and said this: the court has been working to address the pending motions from February. The filing was November of 2022. All right. All right. And then come February 2023, no ruling on any motion had been done. Then from February 2023 to October 2023, no ruling on any motion had been done. And then from the 5th to the 19th, no ruling. But Jacqueline Baja, she said, good morning, April. The dates listed in the email you attached were for the potential status you had requested earlier this year. These dates are not at issue now. However, there is a final, and I never requested a status. This is a bold-faced lie. Alex Frondorf did. Okay, these motherfuckers are so incompetent, disorganized, a bunch of liars and a bunch of fucking thieves and shit like that. All right, these dates are not at issue now. However, there is a final pretrial conference on November 2nd, 2023. The court is diligently working on the litany of motions. So you have the awareness that there's a litany of motions that extended all the way back to November 9th of 2022. And then in February, no one has still ruled on them, right? And then even October 5th, nobody, Chris Brown, lazy ass judge, had ruled on them. Then, right? Then even by October 19th, lazy ass Chris Brown had not ruled on them yet, though, right? Right. But due to the volume, has had to pick it up and put it down on multiple occasions throughout this year for older cases and other trials. No, that's not appropriate. Okay, there's a whole case scheduling, and you don't do that. Justice delayed is justice denied. If you're feeling like you're getting in a bind after a particular time, like a 90-day rule, yeah, judge, or even, I don't know, motherfucker, 120 days, you need to let the administrative judge know because maybe you can't handle it. Okay, something needs to be done about this. Yeah, but they don't give a damn because it's because it's me. It's me, little old black me. They don't care that they have my property that is stolen. They already have the awareness. Put me on the back burner. Just deprive all my fucking rights, okay? It's exactly what they did. Chris Brown did it, and he did it on purpose, and so did Brian Spitz, Trisha Breedlove, Spitz fucking Law Firm, Richard Diageo, Alex Fronder, Littner Mendelsohn, PC, and Bonnie Kirsten over there in 22CV008936 is continuing to try to do the damn same. She's of Littner Mendelsohn PC as well. She in Cleveland with Alex Frondorf. These are liars and these are thieves, and they need disbarred. As the civil case, like I said earlier, a man with no honor is not a judge, period. No integrity. Okay. The judge must give deference to criminal matters facing speedy trial issues. Oh, okay. Yeah, so he can go get all the black people in these criminal matters and lie and cheat them and throw them away for the rest of their life, knowing that they got evidence of being innocent. Shit, probably. Okay. Yeah, whatever. The court will have its decisions on the remaining motions issued before the next conference. Then here we go. Here go to October 27th. She sent this through the email thread that the Ohio Appeals 10th Court would not let me submit. When really, this is how I got my notice. So it's part of the case record. This is how I got my notification of a whole court decision. So what the fuck are you talking about? Ohio 10th Court of Appeals, whatever the fuck. Okay. These motherfuckers, everybody need to keep that. I don't trust none of them. Period. She said, "Dear counsel," she didn't say shit to me. "Dear counsel, the clerk is work. I'm a part of this, but she's just talking to the counsel because she's trying to be funny, okay? Because she knew that he did a summary judgment in favor of Spitz that was able to, steal my money and stuff like that, okay? The clerk is working on processing the attached decision. It should post later this afternoon. I hope everyone has a wonderful Halloween, okay? Yeah, have a wonderful Halloween because these ain't nothing but ghosts and goblins and witches and warlocks and demons and the devil himself, honey, that just stole all my money and did that. And I can't wait till they go to jail. And I've already prayed in the name of Jesus, Lord God, bind them all up with feathers and chains and compel them all to hell. All right. Thank you, Jesus. And reverse back onto them each and everything that they have done to me, Heavenly Father, times 100, Heavenly Father. Thank you, Jesus, onto them and their families and those that they love, Lord God. Let them experience exactly what I have gone through. Thank you, Jesus, and thank you, Heavenly Father, times 100. And add any additional wrath that you see appropriate in this particular situation, Lord God, where these individuals came up against your child deliberately, Lord God. Let them understand and know that there's consequences to their actions. Thank you, Jesus. I let you handle it now. All right. Amen. Casted the spell. All right. So April Clark, she notified, so notified by that common thread, right? Mhm. I'm not no lawyer, so this is probably not correct, but I did my very best to get my point across, and hopefully the appeals court will see that. Yeah, I'm not an attorney, so I mean, I just did the best that I could. But basically, what I'm arguing is that there's no reasonable probability that this case won't be looked at de novo, because that's going to happen anyways with this appeal. I had a right to bring this appeal. Also, my argument is that the court erred by way of abuse of discretion. And with abuse of discretion is also the consideration of deprivation of rights under color law. I will be suing Chris Brown in federal court, and I will be going after his securities bond. Yes, I will. I'll be suing each and every one of these individuals individually. Yeah, they all need to be in jail. So I really don't know what the FBI is doing. I don't know what Department of Justice Criminal Division is doing. I don't even know what Columbus Police Department is doing, what New Jersey Police Department, Cleveland Police Department is doing, but this is actual crime. They need to be arrested. Yeah. Yeah. Amen. Thank you, Jesus. So yeah, basically I'm just saying here that they erred by way of abuse of discretion. I've had my rights deprived that were secured by the US Constitution. Yeah, so also down here, the trial court erred as a matter of law by refusing to award me my damages for CVS Health Aetna Resources LLC breach of the EEOC mediation and general release settlement agreement exclusivity provisions. That errors reflected in the decision of the trial. The trial court erred by dismissing appellant alternative equitable claims, which pled a EEOC MSA settlement general release governed by federal law, Civil Rights Act of 1964, existed, and appellee Aetna Resources CVS Health that breached it. The errors reflected as well. The trial court erred by dismissing appellant's alternative equitable claims, which pled the contingency contract to govern the relationship between myself and Spitz Law Firm was breached in the existence of malpractice and negligence, denying my motion for summary judgment and demand for jury trial, and granting appellee a summary judgment, right? So abuse of discretion did take place. Just a little bit of background. It says that the trial court really was motivated by malice. Misrepresentation, misappropriation of equitable property and tribal material facts was known and understood or should have been as evident on the case record. And the presiding judge, Chris Brown, he should have fucking do that, right? Trial court abuse discretion and known improper interpleader where the tortfeasor in the discrimination claim had interest in the subject matter and ownership in the funds that was in dispute. And they had independent liability to me, and it doesn't stand perfectly indifferent in a position that could be said to be a mere stakeholder, which the interpleader requires. Okay. So, and the trial court knows, I mean, this is a whole judge and lawyers, they don't know this shit. I mean, their shit should be taken anyway. Okay, hello, bar associations, excuse me. So the trial court abused discretion by way of not really honestly, objectively, and without prejudice and or bias in issuance of a drastic and harsh decision, including findings of facts and conclusions of law, which did not appear beyond doubt from the complaint, after presuming truth of all material factual allegations and making all reasonable inferences in favor of Spitz Law Firm and granting relief to a alleged tortfeasor in an improper interpleader where there's no genuine charging lien attachment to an EEOC settlement or fund. Right. Okay. So imaginary lien claim by Spitz Law Firm. All right. They don't have anything. They don't have a fund that their imaginary charging lien can attach to. Okay. They merely asserted an indebtedness. That's what I said. There's no identified fund that exists. It never has. Okay. But yet they're in receipt of my money, $15,000 that was stolen. All right. Yeah. Disregarding all the motions and all that shit. That's just the same old thing that I was basically saying before. But basically, it's not cool that the trial court erred by allowing Spitz to gain fruits of non-labor compensated out of equitable property not secured in the court held fund, where Spitz never assisted in obtaining the EEOC settlement where the fund would extend from. Okay. In Ohio, a settlement fund is created when a tortfeasor or his insurer pays the agreed upon amount and receives a release from the victim, right? There's a breach of contract on both ends from Aetna, CVS, and also Spitz. So that's pretty much what goes on here. It's kind of like it's a little bit of a repeat of the same old shit over and over. Pretty much, it talks about here where I declined to settle the employment claims. It goes into what Richard Diageo said. I quoted it. Ms. Parker, I understand your position. I'll revise the draft of the private settlement agreement that I had sent you the other day to reflect the existence of the fee dispute between you and Spitz. I will send you the revised version of the private agreement later today. All right, so it just goes on and talks about that. Here's something else that he wrote. Ms. Parker, as requested, I revised the settlement agreement, paragraph 1 specifically, to acknowledge the fee dispute between you and the Spitz firm, and to delete the language specifically requiring payment of $15,028 in a third check to Spitz. Please see the attached Word document containing red line track changes, which reflect the revisions. If you're okay with the revisions of the settlement, please let me know and I'll send you a clean version. If you're okay with the revisions, do you see that it explains, I told them this shit needs to come out of here or I'm not going to settle. Or why else would he do this? Okay. Chris Brown had the awareness of this. These are liars. These are thieves. Okay. These are not lawyers, and that should not be a judge on that bench. You understand me? All right. I am also re-forwarding all of the other settlement related documents that I had sent yesterday just to be comprehensive. Okay. Yeah. So Richard Diageo, he sent this to Trisha Breedlove. Good morning, Trisha. April has notified us that she is disputing the Spitz firm's claimed attorney fee for $15,000 and that she has filed a disciplinary complaint against your firm in order to dispute the fee. As a result, see, I don't have to lie. I didn't lie to them. I told them every fucking thing that was going on. I told them why I fired them. I told them everything. I didn't lie about nothing. I'm not a liar. They are. Okay. And it says, as a result, CVS will issue a $15,028 check to April Clark, as that amount is technically part of the overall settlement amount due her under the settlement agreement. Does this look like he knows that this is actually due to me as a part of the overall settlement amount directly? I would say so. Yeah, but Chris Brown, he wants this. He wants this sealed over, right? And he also went further. Richard Diageo of Littner Middleton PC, yeah, he went further to give the case law that backs up why he feels this way, though, right? So, what would make him backtrack and change his mind since he was being real cute here? What it was Trisha Breedlove said, "Hold up, wait a minute. Don't you remember you told us you already have 15,000 for us in the express legally binding enforceable agreement? You asked for our W-9. What happened? What happened, boo-boo? What happened, boo-boo? We about to sue you, motherfucker, for your individual asses and everything that you worked for. And your friend Alex, honey. What? And your firm, and CVS, and Aetna. Then that's when he got scared. Then he came asking for consent shit, see? So you see the games? They use me as their scapegoat, people. Their scapegoat to get out of liability and save their own ass from their own mistakes. Richard Diageo's own mistake. So they put it on me, on my back, and causing me more harm and all this type of shit, and end up stealing my shit by the end of the day to make sure that Spitz Law Firm got the 15,028. Okay, because Richard fucked up. But they disregarded all laws and everything along the way because they thought that I was a dummy and that you were a dummy too, public. Yes, they did. But now they know that they're caught because Bonnie Kirsten, she did run over to Franklin County Court of Common Pleas in Columbus, Ohio, 22CV008936 and requested continuance. Wonder why? Yeah, because I had told her that bitch, I put your ass into the IRS. You gonna get audited, motherfucker. You are, and Littner Mendelson is too. Where the fuck's my money at, hoes? Okay, where's my shit? Okay, because 15,028 is one hell of a motherfucking illegal fee deduction from my income. I need to report to the IRS. Yes, and it might help me get a refund. So, but the IRS is going to come asking each and every one of you who didn't want to tell me where my money was if you got it. So maybe they need to come and go and scrape through your accounting of everything that you fucking do and just kind of see, and 9 times out of 10 find something else that you're doing and you're lying about. I'm just trying to figure out, why did CVS Health Pharmacy pay Spitz Law Firm $15,028 when it's Aetna Resources LL fucking C? That's the tortfeasor, right? I don't know. IRS, we're gonna put fraud in on there as well. We're gonna outline that for the IRS too. We're gonna say, IRS, make sure that you audit not only Aetna Resources LLC, but also CVS Health Pharmacy as well, because they told me that CVS Aetna Resources LLC was my employer because that's the name of my pay stub, and it was actually Aetna Resources LLC from their liability insurance that paid me the settlement amount that I did get. So what else is going on with this other part? I'm gonna make sure you guys are reporting the right income and the right taxes under the right entity name and everything like that too, right? Gotta make sure. And also, people, just so you know, Cleveland, Ohio, Alex Frondorf is a liar. He went down to the court when he filed November 9th of 2022, this fake, bogus, frivolous, disguised interpleader. He put in his complaint that CVS Health and the Resources had already met its obligation under the EEOC MSA settlement agreement and general release terms outside of the 15,028 that it needed to hold on to because it was in dispute. But that was a lie. They had not sent me one red dime yet. That was November the 9th of 2022, right? But I put a thing in a reply and I told the court that that was a lie, that I actually didn't have any checks from anybody yet, right? And then miraculously, a girl, senior paralegal for CVS at one CVS Drive in Woonsocket, Rhode Island. She wrote a letter on November the 21st and put it in the air overnight envelope that arrived here on November the 22nd that had 2 checks for me. November 9th, there was actually no obligation that was met. Obligation is still not met to date. Why? Because you didn't pay me full entire, right? You didn't pay. You didn't pay me. You didn't pay. This is part of the overall settlement amount. You didn't pay, bro. Okay. Yeah. So, mm, yeah. So they breached their fiduciary duty as well, right? Okay. What I say, the funds were never safeguarded, despite the fact that there was grand theft of my property. You still should have safeguarded my property, and you didn't. And you safeguarded in a fund. Okay. So Spitz Law Firm has been paid out. How? There's no fund for them to be paid out of. Nobody has the right to just up and take my money that's owed to me by somebody else and decide how to allocate it and how to send it. So what they did was they took 15,028 that they owed me, and they went on and sent it directly to the fucking creditor that said I owed him money. Yeah, they went on and sent it on over there to him, and then they sent the letter talking about, okay, now her judgment is satisfied. Who the fuck do they think they are? These ain't my parents. You don't decide what the fuck you're gonna do. Like, here, we paid it on her behalf out of her money that we owe her. These are slave masters, okay? This is racism and this is slavery. These people took my property because they don't feel, because I'm Black, that I should be able to have property and I should be able to control my own shit. So that's what they did. They seized it without implied or express consent. Okay, they gained control over it. They said, this is ours. We can do whatever we want with it. It's our revenue. We don't have to give it to you. These white lawyers over here say that you owe it to them. Black bitch, we're not going to give you this, even though we owe it and we signed an agreement saying we need to give it to you. No, we're not, because we got a butt fucking buddy, Judge Chris Brown, down at the Franklin County Court of Common Pleas in 22CV00786 and 22CV008947. He's going to conjure up a whole lie and spin a narrative and truth in his own best interest to meet the needs of all of us attorneys and lawyers and things like that. In the same discipline, we all white, we protect our own. Ain't nobody Black about to come along and do anything. Your Black ass already sat up here and told on CVS, bothering and harming Blacks all the damn time. We're all white. We don't care. We don't like you Blacks. Okay, we got rid of your ass already. All right, we got rid of your Black ass. All right. Now we was going to give you a little bit of money, but then you went on and then you didn't want to pay these white people that are lying and saying that they did something for you. But we don't allow nobody to do that to our white lawyer friends. We're all slave masters, and we own you, girl. We still own you. We don't care what no Constitution says or a Hall Constitution. We don't care nothing about your liberty, your constitutional, human, civil property, pursuit of happiness, and all this stuff. That doesn't apply to you. You're not a person. You're a Black. You're Black. We don't like you. We're biased. We're prejudiced. We discriminate, just like we did and made you bring the whole fucking case in the first place. And we do what the hell we want to do with you Blacks. You are our slave. Now, like we said, we're going to take your money. We're going to hold on to it. We're not going to put it in no damn court and secure it. Then we're going to pay our white people, our white slave owners, all of it, because we can. And nobody's going to do shit to us about it either. You are our slave. Get that through your head as soon as you can. Okay? Do you hear me, slave girl? Now, you just shut up and you be quiet. You don't get a jury trial. You're not a person. You're Black. You don't have any rights. You are Aetna Resources, LLC, CVS Health, Littner Mendelson, PC, Alex Frondor, Richard Diageo, Spitz Law Firm, Brian Spitz, Trisha Breedlove, Grace Schumacher, Bonnie Kirsten, Karen Gaster, Judge Chris Brown, the trial court, and every white person that exists, slave. Don't you ever tell on us again, you Black bitch. Leave us alone. We don't have to answer to you. We don't have to tell you where any property is. This is our shit. No one's gonna do anything to us. That's just what Brian Spitz wrote in the common thread email. He told me that in all this year I've been complaining and telling on things and that's been going on, but he can assure me and he can tell me that there will be no criminal, nothing criminal that comes out of this. And that the appeal or out of my appeal, and it's just going to be a whole nother year long of just nothing. He did give me a compliment. He said that I'm a good person and I really should, find, something else to do with my time than have a headache over this. And that is not personal. So that's basically what he said. So, you know, it is personal. He said it's not about my race, but it is. It's about my race. This is still racism. It's slavery. They revoked my property, my liberty, my life, my pursuit of happiness, all of my rights. I don't have a voice. I had no say so in anything. They took my job away. I did nothing wrong. I am innocent in everything. I did absolutely nothing because these three white people want to keep abusing blacks. And when I voiced about it, I got fired while I was actually participating in a protected activity under the Title V11 Civil Rights of 1964. So that itself goes to show you slavery is still real. It's racism. And then you have your white judge, Chris Brown, wanting to seal that EEOC federal law grounded Title V11 Civil Rights Act of 1964 settlement agreement that is race and disability discrimination in this particular case from the public. So the public can't decide. So yeah, and I'll never stop talking about it because it's not okay. It's not okay. I have absolutely nothing, period. But yet I have my autistic granddaughter to take care of and stuff like that. And even though 15,028 isn't a whole lot of money, and these people really do owe me a lot more than that for all the harms that they've caused me, it's still mine. And it's just a shame that this still continues on, but it is absolutely that the reasoning is because I'm Black. And these people really hate Black people. Yes, they do. So, yeah, and hopefully you'll be able to see it. But anyhow, malpractice went on both sides, but pretty much I'm mainly talking about Spitz here with the unreasonable fees for services that they never did render in accordance to the contingency contract. So yeah, they basically breached their duty under the contract, and that's why I fired them. All right, I just went into the details of what I had already told you, that I had never met and spoken to Trisha Breedlove ever. All right, and then this here is where Richard Diageo, after Spitz Law Firm had told him, like, listen, no, let me remind you, you already said you had an express legal binding contract that stated that you were paying us, you asked for the W-9 and everything, right? We're going to sue you. So basically, this is what he said. April Clark, Spitz Law Firm threatened to file a lawsuit against CVS, Aetna, my firm, and both me and my colleague Alex Fronder personally if Aetna sends the 15,028 disputed attorney amount to you. They've drafted a lawsuit and have stated that they intend to file it this Monday if an agreement is not reached as to the handling of those funds. What does this have to do with me? What Spitz does to you personally, or CVS, or Aetna? There is already an established agreement with regard to the 15,028. It's part of an overall EEOC agreement. You have to pay it to me. If they sue you, it's not my problem, Richard. They're going to sue you because of your own personal mistake and the liability that you brought onto yourself. All right? It has nothing to do with me. So don't use me as your scapegoat, but that's what they did. He said, would you consent to CVS Aetna sending the 15,000 disputed amount to my firm to be held in a trust? This goes to show you right here, they absolutely know what their duty is, okay? If consent is received, your duty is to hold it in a fund from the alleged tortfeasor, CVS Aetna. None of this happened though. I said no, I said hell no. CVS Aetna didn't send anything to Littner Mendelsohn. They kept it, they held onto it in hand. Remember Thomas Cocklaw, EEOC, Washington, D.C., sent me a letter saying the only reason why EEOC would not enforce its settlement is because Aetna Resources did not have the money in hand anymore, but yet, yes, they did, all the way until November the 7th, minimum of 2023. All right. EEOC also discriminates, and I feel discriminated against by them, and I've been harmed by them, and I intend to sue them as well. And Thomas Cocklaw and all of those motherfuckers individually. Yes. Okay. Yeah, I got to get to that. I mean, it's just ridiculous. Yeah, these are all wrongdoers. Ain't nobody stepping up and stepping in and getting me my fucking money and any and all my damages and just slapping some penalties and punitives on these people. It's crazy. No, and you know why? Because I'm black. Stop being so dumb. This is racism, this slavery. Don't give a fuck about me. I don't have no rights. I'm black. The Constitution doesn't apply to me. It doesn't apply to black people. That's why they keep doing this shit. You shouldn't have no property. They say when you can have property. You don't have any liberty. You can't pursue any happiness unless they say that you can. And if you tell them one of their own, then by all means, you better watch out. Okay. So anyhow, he said, once we are advised to the resolution of the fee dispute, we will proceed to distribute the funds in accordance with the resolution. This will seem to be a reasonable solution to the dispute. Note this will not impact my clients and any other two settlement checks to you in accordance with the agreement. And the agreement says that all of it needs to be sent to Littner. But anyways, they didn't do any of this shit, people. Okay, it's liars. All right, so I told him, listen, no, I don't agree to holding my property in any regard. No separate action exists in the fee matter with Spitz Law Firm, and they have no right to my property. A subsequent update to the disciplinary will be submitted online today as this matter continues to cause issues with me closing out my harms I've suffered. Okay, I tell them right here, I got these different types of mental health issues going on that you keep exacerbating. This is part of my disability. Okay, anxiety and PTSD and major depressive disorder. Okay, the job discriminated against me because of my anxiety, PTSD, major depressive disorder, and my race. I'm black. And it continues. Their attorneys, Diageo, Littner Mendelsohn is doing it too. It's just an overall discrimination. These people hate blacks. They just want to kill you, right? So he also said, Ms. Clark, I was not asking for your consent to have the money sent to Spitz. I was asking if you would agree, because you have to agree, to have the $15,000 held in trust in my fund. Okay, I mean in my firm. They never held nothing in no trust anywhere, nowhere. You have to. Spitz has threatened to sue me and Littner. I don't give a fuck. SCVS if we send the disputed amount to you, as they think they'll never be able to collect. I don't give a fuck. It's not my problem. Motherfucker, you better read the EEOC settlement agreement shit and send me my shit. I don't give a fuck about none of that. So this is why they came up with their lie, him and Alex, and all of these motherfuckers got in cahoots with this bullshit. And that piece of shit, rogue ass, Chris Brown, lazy ass judge. Fuck all them. These is human beings. They want to exercise their power and authority, thinking they're gods or something. These slave master motherfuckers. Fuck all these white people. This is ridiculous. You don't sit up here and do. These are racist. Other white people should be pissed that they did this shit. Okay? Bullshit. Anyways, I said, please note at this point I'm feeling placed under duress. I mean, they just kept bothering me with this bullshit. After I told him that, the motherfucker, and then they came up with the interpleader fake ass shit to file. Okay? Using their legal expertise and legalese and knowledge and stuff like that to conjure up some type of bogus misrepresentation to put in a fucking court of law and shit like that. Okay, to ultimately steal my fucking money. I've been going through this shit for a whole year. Brian Spitz still has my stolen property in hand. Ain't nobody gave me my shit. I don't even have a receipt. I'm getting ready to take negative $15,028, a deduction on my motherfucking taxes for some fake ass legal fees. I don't owe nobody for no legal fees, but they debited my income for that. I'm about to get my deduction, but you can't give me no receipt. Brian Spitz is nothing more than a fucking creditor. Okay, that said that I owe him something. He has to prove that. I disputed it. He has to fucking prove that. He's in violation of Fair Consumer Protection Act as well. You just don't steal my shit. Even if it is a fucking legitimate summary judgment, don't nobody have the right to just go in my purse and take the money out and go ahead and pay Spitz. Don't nobody have the right to go ahead and do an unauthorized debit to my motherfucking bank account, take $15,028 out and just give it all to fucking Spitz. That's exactly what CVS Aetna did because I'm their slave. That's exactly what Littner Mendelsohn did because I'm their slave. That's exactly what Richard Diageo and Alex Frondov did because I'm their slave. That's exactly what Chris Brown did, rogue ass judge, because I'm his slave. I'm Brian Spitz slave. I'm Trisha Breedlove slave. I'm Spitz Law Firm slave. I'm Greg Schumacher slave. I'm Nick Curtis slave. I'm all these white people's fucking slave with my black ass. Okay. So anyhow, basically, I've said all of this before that's over here. I'm just saying, in my conclusion, a crime has been committed. my US constitutional rights were deprived in totality. And in the instant, this is of public interest and public policy, which it is. And that's why I need to bring it out here to the public and you need to know about it. These cases, again, Franklin County Court of Common Pleas, 22CV007866, 22CV008947. That was Franklin County Court of Common Pleas, has now been transferred over to appeals in Ohio Court of Appeals 10th District, 23-AP670, 23-AP671. There's still a pending case where I'm suing Aetna Resources LLC and CVS and Franklin County Court of Common Pleas in Columbus, Ohio, 22CV008936. The judge is Michael Holbrook presiding. There is a motion right now pending to unseal the EEOC agreement. And everybody and their mama is trying to avoid addressing that because everybody knows that they're caught. So Michael Holbrook can go ahead and get his ass caught up in this motherfucking shit too, or he can do what's right because I'll bitch, I'll get your ass for deprivation of rights under color of law too. Fuck all y'all. Give my case to a black person. Give my case to somebody black. Fuck this shit. I asked for a jury trial because I need public opinion and public scrutiny. I need real individuals that can be objective and they don't have any true interest in ownership in this motherfucking subject matter or the funds, nor are they in any societies or to have any discipline linkages. No, none of them are all of them lawyers and one that made it to be a fucking judge and they all in the same they all do shareholding and investing in real estate and politicking and all that shit together and scratching each other's backs and pulling each other's dicks and shit like that. I want these motherfuckers in jail. Hell yeah, I'm pissed. What would you do if somebody stole $15,028 from you and then made up a whole fucking lie? Okay? Because of the color of your skin and they hate you so much that you're black. Okay? Ain't nobody standing up and speaking up on my behalf, not even no black folks. I done said it before, nobody is, but everybody knows it. Joyce Beatty's office knows it. She's black. Her black ass know it. And her constituent advocates, and ain't none of them motherfuckers doing shit. All these people know it. Okay? It'd be the blacks against their own as well. All right? But I'm gonna tell you what, I'll put this shit out here. This gonna be a motherfucking landmark case, and you're welcome, and you're welcome, and hopefully don't nobody fuck with you and steal your shit, black motherfucker. Okay, you're welcome.